You're on.
All right, we're starting late. You're supposed to be in charge here.
I'm not in charge of the day-to-day, I've been informed.
Oh, good enough. Well, yes, pink, always.
Everything fishy or
Well, dolphin. I mean, it's perfect.
I'm not sure why she.
Y'all sit on that, right? You didn't know me. All right, good evening and welcome. Thank you for joining us here tonight to talk about intellectual property. I know nobody had anything better to do on a Saturday night at 7 o'clock than come listen to us drone on about intellectual property.
If we had something better to do, we wouldn't be here.
Okay, so
That was a sick turn, honestly. That was great.
I'm your host, Jim Nettles. I write science fiction, urban fantasy, bit of horror, bit of this, that, and the other. I do a lot of nonfiction stuff. I am a partner in a software company, a consulting company, a few other things. I deal with a lot of IP. I begged Seska years ago to put this on, and we've been doing it now for a number of years. I've now dragged a couple more friends of mine up here that haven't been here before, so I have attorneys. Don't take anything that they say as legal representation or their attorneys. They'll charge you. Twice, yeah, twice. Don't forget, if you're finding this useful and valuable, rate it in the app. Because if you want more of this kind of content, especially where you're learning about how the sausage is made and how to do all this stuff, write it in the app. Leave some notes. Tell people that this is helpful. We've been growing a lot of this here at Dragon for a number of years, but it took a lot of years for me to talk them into doing it because it's all about fandom and fun, and she's like, you're no fun.
I mean, you're fun when you've been drinking, but you are required to be on the sober side for this.
I'm on the sober side. Why not? But anyway, so...
No, that's why we have the rules.
Also, don't forget the charity, Arthritis Foundation. After hauling books up and down the hills, my knees are not happy.
Yes.
So, give early, give often, and it's greatly appreciated. That is part of why DragonCon is here, so fandom can help support all kinds of great causes. So I'm going to ask my panelists to introduce themselves, and with a little bit of trepidation based on a couple of the people I drug up here. So Dwayne, go first.
Hi, Dwayne Goetzel. I'm an IP attorney from Austin, Texas.
Bethanne Kim. I work on the 1632 and Beyond magazine, and I have previously worked for a very successful blogger. I have lots of friends in the IT industry, and I worked for Disney before that, so if I'm giving you an example, don't assume it's one property or another, it's more generalized information.
Nice disclaimer, well done. Yes. My name is Toni Weisskopf. I'm the publisher of Bethanne Books, and we have numerous long-running series, which I understand are now called IPs. So.
I'm Courtney Lytle. I'm going to move back away from the mic before I blow you all out there. I'm an intellectual property attorney here in Atlanta. I'm a partner at Culhane Meadows and an adjunct professor at Emory University School of Law. Mostly specializing in copyright, but on the transactional side, not litigation.
These people are all so much smarter than me, and I feel
It doesn't take much.
very intimidated.
Maybe you crowds for a living.
Yeah, I am mostly a word monkey. This is what I think is my official title. I've written a lot of books. I think I'm on like 43 or 44 now. I've worked with lots of people in their IP. I've had people work in my IP. My wife and I also run Shadow Alley, which is a predominantly lit RPG, a progression fantasy, and high fantasy publisher. We have about 25 other authors that we work with almost exclusively, and we do about 2.5, 3 million in revenue a year. So we've grown it pretty substantially. We do lots of IP deals with other companies, with Podium or with Audible, with Webtoons. So I know that everyone's like, oh, IP, this is so boring. IP is money. Money is the greatest, most exciting thing in the world. There's nothing that I want more than that. So I am super happy to be here.
If you want his attention, just hold up a dollar bill.
This is it.
You will be, being an author, will hold out a garter belt the whole day.
I am a mercenary writer. I have to work for my supper. I have to dance for the men. It's the way it works here.
So we really do appreciate everybody coming out because this is a critical thing. So how many of y'all are writers trying to be writers or have made the poor choice to be a lifelong writer? Artists? How about about getting into game development, other kinds of IP like that, software, fun stuff like this. What about physical products? Merchandise.
Yeah.
Something that you can actually fling hold up as your scepter of power that I'm going to use when Courtney goes too long. We've done this before. So,
He's not wrong.
I want to start with this notion of intellectual property, right? Because when you own a business, especially in creative spaces, and down here in the writing tracks, in fantasy, you know, some of the laws we're going to be talking about kind of are a fantasy, like if we get into some of this. But if we look at this notion of intellectual property, and I want to start with copyrights, because again, that's probably the thing that's going to affect the vast majority of people in here first. I want everybody to give kind of the 90-second version, except for Courtney, where it's 60-second version of, let's talk a little bit just in general around copyrights. I deal with a lot of copyright and IP, but I want you guys to sort of dive into this. Dwayne, you're up first.
Cool. I'm going to give an even higher level of view of that because I think it's useful for everyone to understand kind of the different buckets of IP. So if you take a book, a copyright is protecting the content of the book. A trademark could be the title of a book series. A patent can protect the idea of how you would manufacture a book. Whereas a trade secret is something that is important to you in the running of your business that isn't published, you keep it to yourself, and it's to use Courtney's favorite phrase, secret sauce of running a business. So there are those four primary buckets of protecting intellectual property. And so at a real high level, I think it's kind of a useful analogy that people understand what fits in what bucket.
You missed one.
Did I say patents, trade secret, copyright, trademark?
Designs.
Design, yeah, it doesn't work with a book. So,
It does when you're dealing with UK auditors and so that.
yeah, I know.
Yeah, well, I did. So, all right. So Bethanne, what do you want to kind of add, especially in relevance to the project or the IP you're managing?
Okay, the 1632 universe, I don't know how much any of you know about it, but it's an alternate history universe, and there are about 175 people who have written in it. Eric Flint wrote the original story in 2000, and now it's sort of split in half, where Toni has the novels at Bain, and we have short stories at 1632 and beyond. 1632 and beyond is like the feeder leagues for a sports team where you can come and you can get started in it. And we love new authors, and we have no shortest length. And we have a process for getting people in there. But every time I go and put a new issue up for sale, which is the first of every odd numbered month, we have a new magazine up for sale. There's a little button I have to click on Amazon that says, I either own this, the copyright to this, or I have permission from the copyright holder to use this, which we do. We have a contract saying we can do it. Bain has a contract saying they can do this. So no one else has a contract for 1632 and beyond. For the 1632 universe, if you want to write in it, you have to go through us or get permission from the family, because it's something that was created by Eric Flint, and his family controls it. So that's one aspect of copyright, is that you can have something that you have permission from the original copyright holder or the person who's inherited it to use that copyright. Otherwise, it needs to be something you created. I wrote some zombie stories, right? I can go write anything I want in that universe because I'm the copyright holder and I own it, so I can do whatever I want. I can give anyone I want permission to write in that. I can't give any of you permission to write in Eric Flint's universe unless you're writing through our magazine, because I don't own it. Does that make sense?
So Toni, y'all have what, 2 or 3 books published at this point?
Oh, Bain has been in business for 40 years now, so we have, so we have literally millions of books in print. Not a million titles. We are not Amazon yet. But the way that copyright directly affects me as a traditional publisher is that I have a contractual obligation to register my author's copyright with the Library of Congress. And we can talk about inherent copyright and registered copyright. But that is how it directly affects me, is that I am legally obligated to do this thing, this task for the authors. And that can become important later when you are trying to protect IPs.
60 seconds.
Okay, against my better judgment. Courtney.
So I get like 30 minutes, right?
Seconds.
One thing I think might help clarify a little bit when we talk about copyright, I want a better analogy, I don't have one, so we're going with the bundle of sticks. If you are the copyright owner, you have a number of rights and they're given to you by the federal statutes. There's no common law copyright, nothing else, it's only what's defined by statute. And the statute gives you basically exclusive rights to copy, to make derivative works, to distribute it, to perform it, and a few others that don't really apply here. You can give away little, so consider those exclusive rights a bundle of sticks. Seriously, y'all are creative. If you have a better analogy when I'm done, please tell me.
I will give you a primer for that before we do this again.
I
I've been trying to get you past that bundle of sticks for, what, 10 years?
Yeah, I know, but everything I think of doesn't work. It falls apart in the second layer of use. He's burning my time. You saw that, right? Oh, the visual bundle of sticks. So Dwayne can give away his individual pieces of that copyright.
For me?
He can give one, well, he has to Jim. He can give him the right to, I don't know, to publish the book. He can give other people rights to write in his universe. It can be either an exclusive or a non-exclusive right. It depends what the copyright contract says. The law isn't going to answer any of those questions. Well, can I make t-shirts? Well, what does your contract say? So your contract is what's going to really control what rights you either have been given or are giving away. That's not a matter of the statute. That's what you agreed to in writing, by the way. And never download crap off the internet. You know how you can't believe everything you read on the internet? Because sometimes, I know this is going to shock y'all, people write things that aren't true.
Well, the other thing too is that you're not necessarily giving them away, you are selling them for a specified period of time, right? I will give you $5 for this right to do an audiobook, right? And exchange has happened and we have a contract to do this thing, right? So giving, I'm going to quibble because I'm an editor.
That's
and
fair.
I get to do that.
You can give it away, or
you
you can sell it.
Or you can sell it, yes.
So all of these people are vastly more qualified to speak on this. I will say as a writer, though, and since a lot of you are writers or artists, that it's important to understand that copyright automatically exists. So when I publish a book, or when I publish a book on behalf of our authors, we also register it with the Library of Congress. But inherent copyright does exist for you. So the second that you create an original work, it's on your Word doc, that is protected by copyright. And I think that's really important because a lot of people or authors are afraid to share their work, especially in the online space, Road or Wattpad or other places where authors are going to sort of get exposure. And they're really afraid. They're like, if I put my thing up, it's going to get stolen. And that does happen, but not as much as you think, because there are those copyright protections in place that allow you to make sure that if bots are ripping your stuff off Road or Wattpad and uploading it to Amazon makes it pretty easy for you to sort of litigate that quickly and get that stuff pulled down. So you already have some sort of
We're twitching here, we're twitching.
Yeah, and I understand that. I know that might be but it's important to know that you have some copyright protections, like from the second that you create an original work. If you're creating fan fiction or something like that, that might not always apply, but you do have protections from the moment that you create this new thing.
So I know we've got a question right here.
I thought you guys were publishers.
No.
Can I field that?
Go ahead.
I think I know where that's coming from.
Yes, you got 30 seconds from the chair.
I speak about the new copyright law and the old copyright law. Well, the new one's from 1978, so bear with us. But under the previous act, under the 1909 Act, you did have to publish it with notice, and that's when your copyright would start to attach. And it had to be filed, and it had to have notice. There were a whole lot of formalities. Now, although the term inherent copyright is not legally correct, the concept is true. As soon as you have fixed your work in a tangible medium, which does not have to be stone or even paper, computer memory is just fine, your federal copyright now attaches. The publishing or not published thing is no longer at all relevant. What is relevant is it fixed in a tangible medium and owes its origin to you. The next step of registration is important though, because you cannot enforce any of those rights without having registered it.
Right, so if you actually become successful and somebody steals your work, it's so much more helpful to have that registered copyright.
No, 100%, but especially in the spaces where a lot of authors are working now, because the ability to sort of get visibility on your thing, like Wattpad is really successful for a reason, and Royal Road is really successful for a reason, and it's because it allows authors and writers and illustrators and artists to get their work out. DeviantArt is another place if you're an illustrator or a visual artist. So your stuff is out there being exposed to the internet, and it's not necessarily published in the traditional format. You haven't.
But you're still giving up first right of publication.
That's right.
One thing I wanted to add, to dovetail with what Courtney said, is that yes, once you create a work, you have a copyright interest in it. However, it is critically important that you register the copyright, particularly for this reason. Most people aren't aware of this, that if infringement occurs prior to you registering the copyright in the work, you cannot recover attorney's fees and you cannot recover statutory damages. You can recover your actual damages. But that's very, very difficult with a creative work. How do you prove, oh, I would have sold 10,000 books, but for someone else's infringement? I would have sold 10,000 copies of this painting, if not for the infringement. With a timely copyright registration, you can get statutory damages, which are up to $150,000 per work infringed. And this is the big ticket item, attorney's fees, because we are extraordinarily expensive. And so you want to be able to recover that. So the sooner you register, the better off you are, so that if infringement does occur, you've got that timely registration.
And we should point out too that registration with the Library of Congress is not free. It's a small but real cost that you have to consider. Is it worth it for me to do this?
Yeah, it's about, I think, $35 to $50
It's
per
raised
hour.
to
It's gone at
65
65.
now.
It's 65 now? Okay.
Yeah,
And if
but
it's
it's a
multi-author.
very easy process.
It is.
Y'all do not need to hire me or one of
Yeah.
my brethren to
No.
do that for you. It is
No, you-
simple
But
and
Dwayne will
it's
charge a lot for
fairly
it.
inexpensive.
Actually, not as much. It's only about $250 to $300 for a copyright application, but Courtney's right. It's not that expensive. It's not that time consuming.
So before we go too far, and I've got a couple of questions, I don't know if you guys can hold on to this, but there's one topic I want to make sure we cover, and I'm going to give plenty of time for questions because I think that's a big part of this is making sure we answer what you guys want. There's one thing I do firmly believe we need to discuss that we did open the taps on a little bit last year, but now have somewhat more information on. And again, my heart's going to kind of twitch a little bit as I utter the words AI, generative AI. And how this is specifically impacting you guys and where this is flowing at through the process, because I'm involved in some of the actions and consulting on some of them as well. So Bethanne, I'm gonna throw this to you because I don't know if you've gotten submissions that you looked at and went, well, this crap, or...
Honestly, we have, submissions for us are through bainesbar.net, and at this point, they're pretty much still through people we've known for a long time. So, if Ivor Cooper tried sending us something that was AI, trust me, we know, right? And Ivor is not sending us anything that's AI. So we haven't, we have been talking about our cover artist is moving into doing something new, and we're trying to find a new cover artist, and a lot of them are working with AI, which we're trying to avoid for as long as we possibly can. I mean, it's possible there will be some point when...
Well, now it's going to be, if you've got digital art, it is there in some way, shape, or form.
So,
but if you're...
It hasn't been, I don't feel like it has impacted us a great deal yet, except in terms of trying to find new cover art.
Toni?
Yeah, but luckily I'm not on the first lines of the slush reading either for the novels or for our short story contests. I am told that, yes, some of the short stories that have been submitted were clearly AI. They were clearly identifiable as AI. And what AI is a terrible term, right? It is artificial, but it's not intelligence. But it is getting more and more sophisticated, right? And how these tools are used by writers is going to be interesting. So far, it's been obvious. There are commercial programs that you can get to run things through and tell you, yes, we have a 80% confident that this is AI or not AI or what have you. And I expect we'll probably be using those in the future as they too become more sophisticated. But as they become more sophisticated, the alternate programs become more sophisticated too. It comes down to Turing test, right? If it's a good story, do I care whether it was used using a program? Maybe I don't. Maybe I don't.
I'm not sure I can pass a Turing test.
Well, I mean, generative AI has passed Turing tests,
Yeah, it
right?
has.
But so far as we know, I don't think anyone has passed themselves off as a human writer, and it be in fact all program written. I don't think we have gotten to that reveal yet. Will we in the next 5 years? Yes, we will.
So this is certainly not something that we've dealt with personally. I have a very strong stance against the use of AI. Like I want artists to make art. I want those artists to be human. I want to support human artists doing a human endeavor. That's important to me. So even though Midjourney is awesome, and in 30 seconds you can create some mind-blowing art, I'm gonna pay $1,500 for someone who's gonna take 6 weeks to do something that's probably not as good, because I want humans to do art. That's important to me. With that being said, I know for a fact, because I'm sort of connected to the indie community, that there are lots of successful authors that are absolutely employing ChatGPT and other similar large language models. The output, it is probably altered enough to be copyrighted. I think it has to be, like, you have to alter
30%.
30%, I think is
I'm
the
sorry.
threshold.
I hate to
Oh,
disagree
that's okay, I don't know,
with someone.
there's so much.
There's no numeric test for copyright. Just pull it back to yourself this way. Most lawyers are really not good at math and science. The standard rule is if we could do math and science, we'd be doctors.
Take that for attorneys can't give you clarity.
But so, anyone who tells you there's a rule, 5 seconds of a song, 30% of
Yeah.
a work, no. There's no quantitative rule in copyright. Don't trust any numbers or any quantitative rule in copyright. They are not correct, and they will not hold up anywhere.
And that is totally fair. I think with the AI, it's like so sort of leading edge that legislation is not caught up with it in appropriate ways. But I do know that there are authors, very successful authors, who use ghostwriters, and that's what they're doing, is they're replacing their ghostwriters with ChatGPT and other similar programs. And then they're doing extensive editorial passes to try to clean them up and make sure it's a coherent narrative. And it's not, it's not press a button, get a novel. But I know, I've talked to some of these authors and they say, yeah, it's like 30% or 40% of me writing a novel versus 100% of the time it would take for me to write a novel. So it's still not like just click a button, get a thing. But a lot of these authors are saying, oh yeah, this has allowed me to increase my output by 90%, and instead of doing 6 books a year, I'm doing 15 books a year. And I'm seeing that more and more in these spaces, and they're obviously not upfront about it. They're not telling these are all conversations that are happening behind closed doors. But more and more of that is making its way onto Amazon, and a lot of readers are finding it hard to be able to identify that.
And the bottom line for this, and the whole AI tool question is, how do we get money to the creator?
Yeah.
The initial generative art programs did not get money to the creator, and that's why they're being sued, and that's why they should be sued.
Yes.
It's the way the language, the model's been trained, that's the biggest challenge.
Right. And the problem is, if you stop paying the creators to create, they won't.
That's right.
So
That's what the copyright system is based on. It's
That's what
incentivizing creation by allowing you to have a monopoly. The rule right now for AI and copyright is completely useless, but at least to the extent there is one, is clear. AI cannot be an author. So humans are the only ones who can be authors, so any work that is created by a machine or a monkey or a border collie cannot be protected by US copyright. So the elephants that paint, no copyright. AI that writes, no copyright.
Interesting.
Now, the Copyright Office has stated that several times, and it follows from the existing law that we've had for ages and ages. So that one's easy. AI written products cannot be protected by copyright. However, when we go to the situation you were talking about where I'm a human and I'm using AI, well, if you're using Word, you're using AI. It's not generative AI yet. So, but you're using it. So at what point does AI stop being a tool that a human author is using and becomes the author itself? And we don't have an answer for that in the law. There's no case law, there's no statute. They're working on it. It's the government, so you know how quick that's going to get you an answer. But the answer about AI work itself is very easy. You cannot protect it by copyright at all, ever. And that's not going to change. What is going to change is kind of the gradients in between, and I don't know what the rule is going to be. No one does, because they haven't figured out what, they don't even understand the question yet, much less the answer. They've published their first round of results, and there's like 4 more coming, but they won't tell us when, so, you know. But AI cannot be protected. Right. And so far, it's not
Who is publishing these results? Who?
The Copyright Office.
Copyright Office.
The ones who will make the rules until Congress does.
Okay.
The Copyright Office tells us how they think the law tells them to behave. They have to follow the copyright laws. The copyright laws are written in the 70s. Obviously, they're not going to address what we're talking to today. So until Congress acts, where the Copyright Office is just applying the laws we already have to this new situation, which we have done in copyright law forever. So that's not shocking or disturbing, but we don't have an answer to the gray areas in between.
Dwayne, anything you want to throw on top?
No, I mean, Courtney's exactly right. There are cases pending right now that are getting at the issue of using someone's work, like feeding in a book, in order to train the data models, whether that basically scanning in a work is considered copyright infringement or not, because, as Courtney mentioned earlier, copyright gives you the power, the right to reproduce, distribute, publicly display, publicly perform, all that kind of thing. So, are you reproducing a work to scan it in order to train a data model? I would argue yes.
Clearly, yes.
But those decisions haven't been decided yet. So all of this is in flux. I know how I hope it turns out, because I'm on board with let's reward creators instead of saying, yeah, everyone's out of work, we're just going to turn it over to a machine. I think that's disastrous for us as a society. Hopefully, the courts will get it all right, and when do they not?
So hopeful. That was, I feel much better now.
Yeah, that's why we need attorneys. All right, so I do want to put one more thing on the table, and then we'll be opening up for questions. And you did sort of start on this, is the notion of trademarks. And I want everybody to kind of also represent where trademarks come into play for what you guys are doing, because again, when you look at the trademark and the process and the pain that it currently is, I want to talk a little bit about trademarks, because I think this is one of those things that's often quite misunderstood. So, Toni, I'll throw this one to you.
For the most part, our authors have not yet been trademarking their work, with the exception of Sharon Lee and Steve Miller. They established a trademark for their The 80 series. And I think one of the reasons they did that was before they came to Bain.
I'll hand you my card so that your authors can trademark their works.
Okay. My loyalty is to Courtney, but thank you.
I got her first.
She did. She's a reader, what can I say?
I get a commission either way.
So, fair enough. And it was before they came to Bain, and they had works published by multiple different publishers, and I think they wanted to be able to defend their work themselves, and not rely on somebody that they had contracted with to do it, because they did not trust their publishers at that point. Legitimate concern. The one trademark kerfuffle that impacted us was the attempt to trademark Space Marine by a British company, I believe. And we're like, mofo, if anybody is going to trademark Space Marine, it's going to be us. What the hell?
So I think it was Warhammer 40K, right?
It was Warhammer 40K. We were there way before you. But that gets into issues of why they were not actually granted that trademark.
Right.
And it's because it was a term that was too much used by other people before.
I think, sorry to jump in.
No.
It's important to to know that from a trademark perspective, you cannot trademark the title of a single book. You can trademark a series, so the Jason Bourne series or something like that. That is proper for a trademark, but not just a single title of a book. So if this is Jim's only book title, for example, he can't trademark that. But if he has a series on business essentials for writers, then he can. But you can trademark your name as an author. So whatever your name is, you're using it in the context of printed materials, books, magazines, whatever. You can actually trademark your own name or a business name or whatever, and then you can protect that and prevent others from using that mark in connection with similar goods and services.
And that may be even more important if you're using a pseudonym.
Yes, absolutely.
One thing that's a little pathetic to note, though, is you don't actually have a right to use your name as a trademark. If someone else has already trademarked that name, even if it's not their name, it's your name, you can't use your own name.
So preemptive
Well,
trademarking your own name.
You can't trademark it if they have. What you can use and not use is going to be negotiable. But if the trademark already exists in the same field or in a likely confused field, you don't have a superior right just because it's honestly your name.
All right, so I'm not asking you to name prices, but ballpark prices for how much does it cost to register a trademark and how much does it cost to establish that?
Sure.
It's more complicated than a copyright.
Yes.
Oh, yeah.
But less complicated than a patent.
Correct. So the Patent and Trademark Office currently charges $350 per class. So all goods and services are organized according to class numbers. So books, printed material, that's class 16. So just multiply the number of classes. Do you want clothing, in class 25? Do you want educational materials in class 41? So $350 per class, generally speaking. A good trademark lawyer can get the application prepared and on file for less than $1,000. From there, it's going to depend on what the trademark office does. If there's a situation where, like the example here, that, someone who's already registered this, then you have a fight with the trademark examiner as to, no, completely different goods and services or different trade channels or what have you. Very, very ballpark estimate is plan on spending about $1,500 to $3,500 to get a mark registered in a single class, assuming in the lower end if the examiner has no issues, higher end if the examiner says, hey, there's something out there and you have to argue around it. If you successfully do so, it's going to be on the higher end of that spectrum. So that's roughly the cost.
We've done trademarks a couple of times for our company name, for some of our bigger series names. It has been a pain for us, so maybe I should just hire one of you guys because it has not been fun or easy, and I did not like it.
That's why we exist, because everything we do wants everyone else paying. Y'all don't want to do it, so we do.
Yeah, and so we had to do it at Amazon sometimes. If you want like a storefront on Amazon, you have to have a trademark to be able to open a storefront. So there's lots of things where you might need a trademark, especially if you're going to go into the indie book space and things like that. I will say, and this is probably based out of ignorance, in the indie community especially, there's a wild backlash against trademarks. There have been a couple of authors, sort of high-profile authors, who've tried to trademark specific genre things, or there's a big one called Cockygate. There was a very popular romance author who had this, it was the Cocky series, it was like a steamy romance thing, and Cocky was in all the titles of her book, and it was part of her series. So there are like a million other like cocky romance things. She tried to trademark it, and the internet nuked her from orbit, and it did not turn out well.
And
so
to be clear, it was not cocky.
Well, I can't remember what.
No, it was. It was the Cocky brothers.
The Cocky brothers.
They were cocky in attitude and presumably also in endowment. So.
Yes. So there's also one where someone tried to trademark a genre, anyway, so the internet nuked all of these people's careers from orbit, and so there's been a hesitancy amongst most authors to do anything with trademarks. Or I don't want people thinking I'm trying to prevent other people from doing this thing. So there's definitely kind of trepidation where trademark is concerned, because we have seen, I don't know if it's justified or not, but terrible backlash against anyone who tries to copyright almost anything. So just bear that in mind moving forward. Whether it's like justified or not, It's like a thing that exists in the world.
Well, it boils down to the cost-benefit analysis, right? Are you making enough money off of your series that it makes sense to actually do this? If you were, selling 5 copies a month, it does not, right? But if you're selling 500, 1,000, 500,000, well, maybe now you want to think about actually, protecting the source of income. The Lord of the Flies is here. So.
I was going to say, if anybody was to take my name, then I can go find a new one. So I'm going to pause for a minute and see, because I know we've got a few questions, and I want to make sure we get some of these. One of the things is I don't want to necessarily talk about fair use,
Did you notice how carefully we were avoiding it?
yes, I know, but I
We
do want to
didn't
mention.
plan that ahead of time.
Yeah, well, the reason I say that is because we do have a fair use and public domain panel tomorrow at 4 o'clock. In the Hilton, and that is, which one, I don't remember, that's one of my other tracks. We're actually going to be spending an hour on it, because this is a very, very gray zone, and I don't want to open that door for Courtney. So, question.
He shuts you down
He
every
asks
time.
me to be here, and then he tells me not to say anything.
That's just for my
He's a mean person.
So, I think you have the first one.
Yeah, so earlier when we were talking about copyright, there was the idea of registered copyright and so-called inherent copyright. When I used to go to school for music composition, and one of the things that I heard was that it was called poor man's copyright, where
I'm sorry. I
You
talked about
just
this
brought
all of
her
my
great joy.
Okay, how many of y'all know the poor man's copyright? Okay, please purge those brain cells. Go out tonight, drink something, and target it with bourbon, because you've got to just forget completely about that. Absolutely no legal validity whatsoever.
Will you explain what it is?
For those of you who...
Or what people think that it is, even though it is not?
I do this in every session, and I hate doing it because now I'm telling more people about it. If the idea is if you take your book, you put it in an envelope, you mail it to yourself, and leave the envelope sealed, one day you can show a judge that envelope, and he'll open it up and say, oh, look, you did write this first. No judge ever, ever, in the history of judges has even considered opening an envelope to look to see what's inside it. So, no, it's not going to work. And besides, think about postage rates right now. The $60 the Copyright Office charges is probably less than what the post office would charge you to mail your manuscript.
Plus, the manuscript might get to you after the theoretical judge 20 years from now.
So yeah, just no, absolutely not. No validity whatsoever. Sorry, but no.
No, that's exactly what I asked.
Yeah, that wasn't a diplomatic answer, but
That was
it's...
a good one. No, that's important.
All right, I know I had another question over this way, and yes, sir.
For copyright, your name, your project, I understand, since I started the question, I learned a little bit more about my answer, but if I'm working on a work and it's a large body, does the work have to be complete before I copyright it?
Yes.
Okay, thanks.
Yes.
Maybe not necessarily about copyright, but do you have any opinions or views or comments about NDAs and alpha readers?
All right, I'm gonna start with that one. So the first thing is I'm going to say is this, and I deal with a lot of much greater, much more critical IP. If somebody comes to me and says, will you sign an NDA? When I get done laughing and I cuss at them a little bit, they'll probably also go on the list of somebody I probably will never deal with, because that tells me exactly where their headspace is at and what their level of experience is. Who wants to add to that?
Don't trust Jim with your materials.
Going back to, you said the work is complete,
No, does it need to be complete?
but I think that's like the item you're
It's
registering, like the book is complete. Like if you're going to have a 5-book series,
I see.
that whole 5-book series, I don't like, because that would be 5 separate copyrights.
Right.
So I just wanted to go back and clarify for anyone to make sure you're aware of that. Like 1632 is not a complete work.
Right, George Martin would never get a copyright if his series had to be finished. Right?
Yes. So I just wanted to make sure you were clear, because you were saying about a larger body. So it's just,
With that though, does that extend to the trademark thing where you have to have the
trademark for a series but not a single word?
Completely different rules.
Yeah.
Completely different.
Different statute, different grounding for the statute, different rules, different applications, different purposes, completely different. Pretend they're not even remotely related.
And expect to pay
Copyright
for it.
book one, and it's, oh, sorry, say what you.
No, I was gonna say, continue to expect to pay for it, and it needs to be in use.
Okay.
That's what I'm going to say. For your question, you have book one completed. Can you apply for a trademark for a 5-book series if books 2 through 5 have not been completed yet? No, because you're not using the book series title in commerce yet. And that's the thing about our trademarks is you can apply for something that's called an intent to use application, but you can't actually get it registered until you can prove use in commerce to the trademark office. So once you get book 2 completed, then you can say, yes, this is a book series, I'm applying for, again, the Jason Bourne series.
And this is why we make sure to use the trademark symbol on every book that we have, so that it can be proved to be in use.
I have a question that I just really would love for us to talk about, and it mostly has to do with, so in our spaces there's lots of predatory rights companies, so if a company approaches you, what are things that you should be looking for predatory rights grabs? Like what kind of language should people be on the lookout for? Like, oh, this is a giant red flag and I should definitely not sign this thing?
I'm your publisher and write me a check.
Yes.
Well, that's one, but unlimited time periods, right? And I have this forever, right? No, there's always a time limit in whatever gift of right or sell of right.
If anyone contacts you and you haven't contacted them yet, it's probably a scam. You know?
Yeah, the only thing I would probably add to that is, because again, it's reversion of rights, make sure you've got the ability to get your rights back, but also only license the rights that they have an ability and capability to execute on.
Yeah, remember my bundle of sticks, fascinating as they are, you don't have to give them the whole bundle. If they say, I want to publish your book, you give them the right to publish a book, not everything else. And
So
if
they're
the
asking
creditors
for all
usually
rights,
say,
that's a
assign your
red flag.
copyright to me. She says, assign your right to publish to me. And she pays you, you don't pay her. That's, Jim was saying that's huge. If they say, I'm your publisher, here's how much it costs, they're a printer, not a publisher.
Your services.
You may be asked to get ice for the, hospitality suite, but that's it, right?
Can confirm.
So anecdotally, I've heard that if you're trying to register that under pseudonym, it could be a way that people can go see the paperwork, find out your actual name, and it can be difficult to maintain your privacy. Is that correct, or can you go for copyright under your pseudonym and still have it be something that's usable?
We're all looking at you.
Right.
Well, also, maybe a bag full of keys instead of a bundle of sticks.
Why do I want a bag full of keys?
No.
Keychain.
Oh, okay, a big keychain, prison warden's keychain.
Yep, and I'll
Okay.
issue this.
Prison,
I can work on that.
all right, so the question is, once you register the copyright, does it become a public record that people can look up and then find out who you are? So yes, the answer is yes. It does.
With the pseudonym, it's a little different, but I mean, the government still wants to know where to find you. And anything that you have to fill out on a form to the government is never going to actually be proper.
I have heard that, again, anecdotal evidence that I don't trust, but incorporating or some forms could help you get around that so that your name isn't directly.
To a certain extent, yes, but there's a new law that's being challenged, so we don't know about the full application of it yet, that says that all of the owners of an LLC have to be registered. I believe they call it the Transparency and Privacy Act, and it's really neither. But
your privacy is transparent.
Yes, there we go. Perhaps that's
This is
what
not
they
the
meant.
EFS track.
So in theory, that helps. It's one extra step, but at the end of the day, the government knows who you are, therefore it's discoverable.
And the other thing to keep in mind, the copyright form you submit has a space for who the claimant is and who the author is. So if you're claiming under the name of a pseudonym, that would be one, but whoever the actual author is going to be listed on there also. And that is public information, but the work itself is not unless there's litigation or some other factor like that. So someone can look up the name and so forth, but they can't get access to the deposit copy. That is the actual work that was submitted with the application.
But the one thing I will add to that is privacy doesn't really exist anymore. If somebody's motivated, it does not take much to run down. You can do everything you want to do. You can use a pen name, but blocks keep out the honest and the lazy.
Could you discuss derivative rights? How broad are they? What does that actually mean?
You want it? You want me to?
Go ahead.
I said it's mostly a lawyer question. Derivative rights are the second right in the statute, section 106. Go ahead and write that down. It's important. It'll be on the exam. But the derivative rights are the rights to make other works that are based on your original work. It's sequels. It's spin-offs. It's merchandise. It is screenplays. It's ice shows. It's anything you can do based on the original work. And that's one of the exclusive rights reserved to the author of the original work. So if I write the first book, I get to write the next book. And no one else can do that unless I give them that right. There's my bouquet of flowers or Warden's keychain or whatever I need here. I can give someone the right to write a sequel. I can give someone the right to write a screenplay. I can give away or sell any of those rights. But the derivative right is one where a lot of money, honestly, is made. So the derivative rights, in a lot of cases, are more important than the initial right. I mean, it's not a real shocker that usually the first book doesn't make as much money. The additional ones are the ones where you get more renown, you get more famous, then hopefully they buy the first one too. But the derivative rights are very valuable. But they're just like the rest of the rights under the Copyright Act. You can keep them or you can license them out, whichever you prefer.
I have not yet.
Do legal work for the art show, so yeah.
I'm still hooked on which book do I have turned into an ice skate.
Casey and I, we got that covered.
Yeah.
So I think the next one I saw was.
Hi, let's go ahead. And to preface this, I'm more interested in how you feel about this than, if this were litigated, what would happen. So at what point do you, what is the smallest thing, the smallest point at which you feel that an author is owed for their work? So if an author uses the same first name or takes the first sentence of one novel and writes a whole new novel after that first sentence, or you come up with a great neologism and someone else uses that neologism.
Our contracts, one of the rights that we have is the right of quotation. So if you are using a copyrighted work as a quotation, so that first line, you should be asking for permission, and you should be recompensing the original author if you are exploiting it for commercial purposes, not for purpose of review or academic purpose. But so yeah, it is as small as that.
That also kind of falls under fair use, doesn't it?
Yes, but we're not allowed to talk about that.
We are
not allowed to talk about that.
Because once that door opens, we'll be here for another couple of hours.
It's important to note that to your question, the Copyright Act does not protect short phrases. So, and this is where you get into the legal nuance of it. How much of a taking is it? Is that one phrase the heart of the work, and by taking that, you've destroyed the market value from the appropriated work. So it's not just as simple as saying, oh, I'm only using 5 words. Maybe those are the most important 5 words of the work from which it's been appropriated. But generally speaking, the Copyright Act does not protect single words or short phrases. So.
Yeah, and then one thing I'll mention, the reason I pulled this book out is this covers a number of use cases because it is academic, sort of. There's a whole bunch of PhDs in me. But it's derivative work because it's essays based on film and taking and describing how it ties into very folklore and mythology, but it is derivative because it is an explanation and exploration of different films. So there's a ton of footnoting, there's a ton of going through and documenting. You go through the usage, so when we talk about derivative works and academic use and some of the other things, this actually is the reason I drove this out. So another question.
So I think it's important when deciding, whether to trademark something or not. I think we all know that trademark trolling exists. So, if you make something, publish it, and after that someone has trademarks it, and you don't know if it's registered, it goes through, what kind of damage would you be looking at financially? be challenged with that trademark, or if you get challenged with that trademark?
It's important to note we have this strange system, unlike most countries that operate on a first-to-file basis. We have two things. We have common law use, which is just I've been using something, and then your rights just depend on the geographic scope of use. The example I always use is someone like McDonald's or Starbucks. If they've never registered their marks, they would still have really broad rights because they use them everywhere, right? The purpose of getting a registration is so you don't have to deal with that kind of factual thing of, I've only been using it in Austin, I've been using it in Georgia, that kind of thing. The registration gives you presumptive national rights so that you can prevent a subsequent user from using that mark for the same or similar goods and services. So in your context, if you've been using something and someone else comes along later and registers it, then you might actually have prior use based on your common law rights, where have you used it and how and so forth. And you might be able to prove that this later registration has damaged me because I'm the one who was using it first and they registered it, shouldn't have, they didn't have rights to it. And so it's really going to come down to what are the actual damages that you can prove. Can you prove lost sales? Can you prove that customers have been confused and, oh, I went to this person when I really meant to go to you? All of that goes into the mix. Well, that's really expensive.
Dwayne just said handing your credit card and mortgage.
Yeah, right. How much justice can you afford? I do want to just clarify, that's trademarks, not copyright. They're absolutely completely different analysis, completely different rules. And that was 100% correct on trademarks, your trade name, your brand name, series name, not the contents of your book, which is copyright.
This goes back to the pseudonym question a little bit. Everything that's pseudonym as goods or transfer. How much differentiation?
I think you should change your name.
Legally, give it up.
No, because for me, because this is not my real name, this is a penny. Part of it's just for search visibility, right? Like it's about eyeballs. We're trying to get eyeballs on our work, and if you have someone else who is already getting a huge number of eyeballs on their work because they're well known, you're going to have a really, really hard time competing against them in the Google search algorithms or in the Amazon algorithms. So finding something that's less common is just going to give you a leg up in terms of just like sheer marketing viability.
It might be.
It might be,
sure.
He doesn't mean you have to change your
No,
name
you do not have to change your
Use a pen name.
Yeah.
Use a different.
I write under a number of different names for different purposes, and so yeah, just pen name.
You don't want to be a Wikipedia disambiguation copyright.
Right, yeah, exactly. Plus you Google the name, so
Yeah, you don't want that.
You'll be somewhere at the bottom of those.
Jim, I have a question real quick. Something that I've seen a lot, and I don't think it gets talked about a lot, is co-authorships. So we have two people who are like, oh, we have a great idea, we're trying kind of drinking, we're going to write a book together. And all of a sudden they're talking about a book and they're starting to outline stuff. What happens then? Who owns the IP if two people worked on it? If you get 50% of the way through the book and the other partner says, oh, you know what, I'm done with this, can you continue to use that work? How do you, or how
What's your contract say?
recommend? Well, that's the question, because a lot of writers do not have collaborators agreements going into it. So, what is your recommendation for anyone out here who's maybe considering co-writing?
Dwayne will write you a contract for $10,000.
Pick your partners carefully.
Both contract and statute actually are going to apply there. If you have a contract, it will pretty generally trump what the statute is telling us. The basic statutory rules for joint works is that you have two or more authors who work together with the intention of creating a joint work, and it has to be contemporary. It can't be, I wrote something a long time ago and now we're going to make it into a joint work. We have to work together with the intention of creating a joint work. Now, how do we know that we have the intention of creating a joint work? For the love of God, write it down. Otherwise, we're going to have litigation, and Dwayne might need a new car. So,
I have two daughters, so absolutely yes.
Oh, okay. So in that case, just a handshake is fine, because he's got daughters to put through college. So, but no, if you want to write it down. And it doesn't have to be written by me or by one of my people. It's better if it is, but if you just write down, we are writing this together. We have the intention of writing a book together. That's better than nothing. The key case is the case about Rent. You know, the composer and writer of Rent died the night after the first pre-Broadway opening, and a few months later, after it became a huge hit, knocking on his parents' door was a woman who had pretty much been an editor of his, the drama version of an editor, saying, "Oh, I helped him write it, I'm a co-author, I want half." And you don't want to be in that position. Well, you don't want to be dead, I assume, but you don't want to be in that position of someone who was never intended to be an author, shows up later and says, "Oh, I helped him write that." So write it down, keep it clear. But otherwise, you're going to be paying, you know, Dwayne a lot of money to put his kids through college.
But seriously, this is like the #1 thing, because authors are so impulsive and we just want to like talk to other writers and stuff. If you're going to collaborate, make sure you have some kind of collaborators. I cannot tell you the number of authors that I have seen burned by this, who are like, "Oh man, now I'm 80,000 words into the book, but now I can't publish it because this person doesn't want to do it anymore, I don't know what to do with it, and we never wrote anything down." It's ugly and terrible, and it will like nuke friendships. Just like a simple collaborators agreement. Simple has one that you can download. The Science Fiction Fantasy Writers of America, they have a stable collaborator contract that you can get for free. Like anything, please do that if you're going to collaborate with somebody else.
Can I?
Go ahead.
This panel isn't for this overall, but be very careful with anyone you're trusting with your IP. You do not want to have a website that you build that has all of your products on it that you can download, and you trust an admin, and you're like, okay, I am not the work person, I am not the Wix person, whatever you're using, and they have the access, and then they decide you have to pay me twice as much every month, and they lock you out and you don't have your own website. Or the person
hypothetically.
Right. I mean, remember, I work with a lot of people doing a lot of things, and be careful you lock down your IP, right? The survivalmom.com is one person, and survivalmom.com is another completely different person. The only difference is the word "the" in the website. So if one of them had gotten both URLs when they started out, life would be a lot less confusing. So lock down your digital IP as well, and you know, and if you're having someone upload to your Amazon account, same thing goes there.
Remember these words: work for hire. You want a work for hire agreement with anyone that is doing work for you, if you can. A vendor, an illustrator, whatever. A work for hire agreement says, you're doing all this work for me, and all of the work, I own all the rights to it. Because otherwise, without that written agreement, you send something out to an illustrator, for example, the law presumes that if they're not an employee, that they own the rights in that. And so you don't want that. To your point, lock down your IP, and one of the ways to do that is work for hire. Sorry.
No. One other thing I want to add, and then I'll get to your question, and we'll wrap up because we'll be a minute or two over. Oh, okay. I know we've got one here. Also in the civil, you'll find a ton of resources. One of them is also called the legacy kit. One of the reasons you want to have this contract is in the event one of the two partners dies, you can still work with your own IP, because if a partner dies or decides, I'm just going to lock this thing up, you can lose the rights to work with your own IP. So, the legacy kit on Civil. I won't tell you what it was named when we were first working on it. It was the O blank kit. So, all right. Quick.
Yeah, it could be, but they're two separate things. Sometimes there's an overlap. You remember when Prince used the glyph symbol? That was, he trademarked that, but there was also enough original artistry to that he registered it as a copyright. So you can use it as both, but that's the rare situation. But typically, again, if you remember my beginning analogy, the trademark's kind of going to be the name for something, and then the copyright is going to protect the content.
So since I've never done anything in time in my life, there's no really a question.
you going to be in the... I am going to come by. Oh my gosh.
The safety net is your work for hire agreement that says that you get all rights. They're just doing it basically like they were an employee. You maintain them all the goods. Because I've seen that situation where an outside vendor will say, okay, you can only use this for, say, 1,000 print run of something, but I'm retaining all the other rights. You don't want that. You want absolutely everything. I'm paying you, and you're giving me the rights to the work that you're doing. That's what you do. No.
There's no agreement that you can download for free that is worthless. Because it's not going to fit your circumstances. And it's usually not drafted well. So even if it did fit your circumstances, it would not protect you well.
So I want to thank everybody very much again for coming out tonight. Again, remember, if this was good for you guys, let's get some ratings in the app. I want to thank my panelists for, coming in and being here this time on a Saturday night, plus everybody deciding to come and hang out with us. There's a little bit of swag up here. Working down from James this direction, you want to let everybody know where they can find you the rest of the weekend? What else you got going on?
Amazon and Audible, obviously, you can find all my books there. Shadow Press has an enormous booth. We have 10 authors out doing signings. We're on the second floor, 2820. Lots of cool books, lots of cool merch and swag and all kinds of stuff. Come out and see us and find your next favorite book.
I do. If you want to, if you
I
need
can
a
get your
lawyer,
card, yeah,
come find me. I've got a card. I'll hand them out.
So we are at Bain.com, BAEN.com. There's such a thing as a Bain Free Library where let you have a free book. That will usually be the first in a very long series. And here at DragonCon, I can be found tomorrow at 11:30. We're here, where we will be celebrating 40 years of Bain books. So this is guys there.
And we have a free issue of our magazine available, and it does list the address for you to get the 1632 first book from Bain Free to the library. And so you can go ahead and take a picture of that. It's free through the end of DragonCon, and clearly digital concerns are of a high priority to me, and I think that would be a great thing for a panel in the future. I mean, that really was a hypothetical. I don't know anyone that's happened to, but it could very easily happen, so I think that would be a great topic. If you want to add that in as a comment, we need more IP panels, not less.
Yes, always more IP panels.
I'm the only person on the planet with a name this strange, so it is very easy to find me. I'm literally the only one. Yes, shamefully, I have Googled myself, and this is the only one, so I'm easy to find.
So you don't need a pen name is what I'm hearing. That's
Yeah.
Now he still does, so that somebody will go and say, on a panel, get Goetzel?
Yeah, I've heard it.
Yeah. Oh, so I am done for the day, I think. Tomorrow I have Monsters and Funny, the Adams Family Monsters. Disenchanted series recap tomorrow at 1. 4 o'clock, the one that might be important for you guys is Steamboat Willie and Tigger 2. How to exploit the public domain. And then Monday I'll be at Classic Sci-Fi. I will be around and available for some other stuff too. If anybody wants a copy, I have 3 copies of stuff up here. And we have swag. I have stuff for people. We do programs like this all the time. So if it's helpful for you guys, come grab some stuff.
Thanks for coming, everyone.
And thank you guys. Thank my friends that I drove out on a Saturday night because they had no lives to be anywhere better than me.
And he's right. I get to talk. People can't leave. I love that.